A warm good afternoon to one and all present over here. I would like to first of all thank everyone for being present. I would also like to thank the ones who have joined us through Skype or I think so Zoom. My name is Himanshu Batra and I work at Masin. I am the moderator for today's session. So the topic that we have today for discussion is a fairly interesting one. It is navigating market turmoil and price escalation in the construction sector. So what we are going to discuss is the strategies for effective dispute resolution and risk mitigation. Now on the panel, we have a very learned people. They are lawyers as well as experts. First up, we have on the extreme right, Mr. Rohit Singhal. Rohit is CEO at Masin. He has appeared as an expert in more than 70 international arbitrations to testify on matters related to delay, quantum, technical, and others. Next up, we have Emma. Emma practices law in London and is presently a partner at CMS within the disputes resolution team. Emma has an experience in construction claims and disputes, and she has represented clients in international arbitration cases, both ad hoc and within institutional frameworks like LCIA, ICC, etc. Next up, we have Camille. Camille is a barrister at Atkin Chambers. She has successfully argued matters in various dispute resolution forums, including arbitrations, DABs, expert determination, and mediation. She has also appeared before the High Court. She has worked with various standard form of contracts, including FIDIC, JCT, NEC, etc. She has also been listed in Who's Who Legal. Next up, in my extreme right, in my next right is Matthias. Matthias has experience at all stages of mediation, litigation, adjudication, and arbitration. Matthias is ranked as a Tier 1 rising star who understands highly complex and technical subject matter and is very detail-oriented and organized in working with witnesses. Now with this, we should come to the topic. Now, how we are going to deal with this session is there is a small presentation that we have prepared. I will walk you through the slides just to set a context, and thereafter we will discuss with the panelists on the issues emanating from this presentation. So we'll start. So see, the issue is with respect to price escalation. So we need to understand what is exactly market turmoil, from where it is coming from. So you see two lines here. There is a black line that's going straight, and there is a red line that is scattered and going at the top. So this is basically a envisaged price escalation, I would say, and this is specifically for a rebar that we call as iron. And then thereafter, this is the red line. This is the actual fluctuation in the actual rates of iron during this very time. So you see this black line that I say is the envisaged is basically based on the indices, the price escalation indices that is being plotted, and this is based on the actual rate of the iron. Now there is a big gap in between the black line and red line. This is what is concerning, and this is what we are going to discuss. So if you see in 2021 to 2022, there was COVID that we saw that had a high effect or a large effect. And thereafter, we had Russia-Ukraine war. And we see that the lines are fluctuating. Next up, if you see at the extreme right-hand side top, there are various elements such as aluminium, copper, zinc, lead, nickel. The rates are shooting up when the Russia-Ukraine war came into picture. At the bottom, you see there is a price index trend. There's a normal price index trend. that was planned, and thereafter in 2021 to 2023, you see a steep increase, and the envisaged is the dotted line. So this is the gap we are dealing with. At the left-hand side, this is basically an inflation rate across the globe, and it increased to a large extent in 2022, especially in Europe. If you see, because of the Russia-Ukraine war, there was a big impact in countries such as UK, Netherlands, Slovakia, everywhere. Now, this is a basic price escalation formula or a clause from FIDIC that I have put here. It basically states, it basically gives a price escalation formula within which the price escalation can be claimed by the contractor to the employer. But what it is not covering is the steep increase that we have just now discussed. Now, this is force majeure. We all are aware about this clause because COVID has come. It's been 2-3 years now. So this clause I've extracted from a recent case that we have dealt with, and it's fairly interesting. So just a broad definition, it states that any event beyond the reasonable control of the employer or the contractor. That's okay. Last para we come. It states that if the performance of the contract is substantially prevented, hindered, or delayed for a single period of more than 60 days, or an aggregate period of more than 120 days, the parties will attempt to develop a mutual satisfactory solution. There is one more interesting clause. This falls within the umbrella of the force majeure. This is war risk. It states that war risk shall mean any of the following events occurring or existing in or near the country where the site is located. It states that near, occurring or existing in or near the country, emphasis applied. Thereafter, I come to the last para, which states that the employer shall pay the contractor for an increased cost or incidentals to the execution of the contract that are in any way attributable to, consequent to, resulting from, or in any way connected with any of the war risk. Now I'll stop here. There are further slides we are going to discuss as we move ahead, but we have some questions for the panelists now. Now I'll start with Kemal, you first. The employers are considering Russia-Ukraine war as force majeure, and the contracts might not have clause to deal with price escalations owing to war. What has been the position of English courts on events such as these? Is it treated as FM, or claims are allowed by the courts?
Well, unfortunately, if you're a contractor in this position, I think it's pretty unlikely that you would persuade an English court that this price escalation events amounted to force majeure, because the general approach of particularly the English courts, but you see it internationally as well, of what is properly characterized as force majeure is something that's outside the reasonable control of both parties and not one or other party's risk. And in a standard commercial contract, the contract price is the contractor's risk, and so it's not deemed to be something that's outside the contractor's reasonable control. So, in my view, it would be very unlikely that you persuade an English jurisdiction court or an English trained arbitrator that price escalation was something that you could claim under a force majeure.
Emma, would you like to add something on this?
Yeah, I mean, I completely agree, and I recall a number of similar attempted claims during the global financial crisis, and projects were just costing more for contractors to execute than they ever provided for in the contract. So it is difficult to bring these types of claims as force majeure claims. I think the devil is also in the detail. Quite often you do get the force majeure clause is drafted by reference to an exceptional event, and also a degree of not being able to foresee that event occurring. And I think that, you know, the issues that we have now, and certainly anyone entering into a contract now is obviously well aware that that there are many price fluctuations and uncertainty in the market, and currency fluctuations, which I know we'll come on to talk about. So these are things that actually you would be expected to provide for in the contract, and it wouldn't be considered to fall within the scope of that type of definition. Force majeure is, of course, a creature of contract. It's not a creature of English law. So always start with the actual terms of your contract.
So what we are coming to is the fundamental principle of risk allocation. So the fundamental principle of risk allocation is that risk is allocated to the party, which is not only in the best position to assume the risk, but also mitigate the risk. But how does a contractor claim this price turmoil and associated commercial impact? What are the ways out for a contractor? Rohit, do you want to shed some light on this?
Now, you see, I'm doing a couple of matters which have got similar kind of clauses. One of them is a big $3 billion refinery project in Middle East, and definitely that, of course, the contract is based on the Middle Eastern laws, not the English laws. So in my case, my contractor, which is a big, one of the biggest EPC contractors related to oil and gas, went and took a legal opinion. The legal opinion came exactly what you said, but of course there were ifs and buts because of the Middle Eastern laws being part of the contract. Saying so, and it's still not into arbitration, it's just a claim submission which is being done. So what contractor has done is it has gone on a kind of a mercy plea, saying that, look, there has been massive differences in the prices which we could have never envisaged. And let's be practical about it. A typical contractor would probably keep a profit margin of 10%, 12%, 15% in that range. Now, the kind of graphs you see where the turmoil has been extensive, the prices of steel have gone up, the transportation shipping issues costed a massive increase in the shipment rates. The equipments, complicated long lead items, boilers, and all those things have seen very increased prices. So what the contractors are right now doing is trying to plead it on a kind of a mercy plea. They are not trying to bring in the legal clauses into picture, but that's what, as of now, the industry is doing it. And I'm also into another arbitration where the contract was terminated. Primarily, one of the reasons was the huge, massive cost impact because of the price escalation. There, of course, the certain clauses are being used to see if there is a possibility to claim the impact. But broadly speaking, it's more of a kind of a request to the employer that, hey, please help me and please help me to complete the project with this kind of price rise. I would have never ever envisaged a risk into my pricing.
Matthias, would you like to add something?
Yeah, no, I think I agree with what Roland says. It's a difficult thing with this sort of situation, because on the one hand, you look at the contractor side and you feel like, well, obviously for the contractor, they haven't really priced for that particular risk at the time, because you can price for risk certainly, but you normally price for risks which are known, not sort of the unknown unknowns. So when you get to this stage where you're dealing with things like COVID, or more recently now with the Russia and Ukraine wars, where you are dealing with things which you really couldn't have envisaged at the time, then you sort of feel a bit of sympathy for them. But on the other hand, if you're from the employer side, obviously this is just completely the other way around. So they will think, well, we've bought this as the bargain. That is the sort of fixed price that we've got. So they will obviously have sort of temptation to just stick to the contract. And I think that the reality in a lot of this is that if you go to an arbitration, then the answer, obviously, and as the rest of the panel has already sort of explained, is that the tribunal will be sort of bound by what the contract says. So you will have a certain sort of result from the tribunal. You would know that basically just walking in. But what has happened also over time, I've sort of observed in some of the arbitrations that I've come across, dealing with similar issues is that rather than sort of going all the way through to the end of the arbitration and getting an award, which, you know, probably both parties would know what the answer is, just based on a matter of strict sort of black letter law, parties then sort of some halfway through the arbitration tend to just come together and think, okay, well, let's just sit down now and think about, well, how do we go forward from here? Because it's all well and good to say, well, what is the legal answer under the contract? What would be the result in an arbitration? It's quite another thing trying to actually finish the project and get something done in order to start sort of basically recouping perhaps some of your losses. Because if you don't have the project done, then all the sunk costs are just gone. So I think the reality is that a lot of the answers that we are looking at now are sort of almost ex-contractual. And it's one of those things as well where you look at a case law from the courts. There are obviously cases, I'm sure some of you have already come across them before, where you have courts accepting that things like COVID can amount to a force majeure under a particular sort of force majeure clause in a contract, and that's sort of unsurprising. But I find that the difficulty in most of these cases is trying to bridge the finding of something which is a force majeure event and the actual impact of that force majeure event and translating that into an actual financial claim, financial compensation. Because the causal link is quite difficult and the quantification of it is also quite difficult, as I think we will probably cover a little bit more of it later.
That's correct. One interesting thing which I would like to add is, which I faced in one of my, cases, and probably Camille and Emma, you may add. If you read this clause, it says war risks. It says war risks shall mean any of the following events occurring or existing in or near the country. Bracket, it says for countries. My eyesight is not good.
Or countries.
Or countries where the site is located. Now, the issue is, let's say there is a project in Middle East and the war is taking place in Russia, Ukraine. The impact of Russia-Ukraine war is seen on the deliverables of, equipments which are coming probably for the project which is based in Middle East. Now, how will you consider this interpretation? Will you say occurring or existing in or near the country? Now, near means, are you talking of 100 miles, 200 miles, 500 miles, 1000 miles? Or are you considering the word near from an economical perspective, that this war of Russia-Ukraine has affected the project in Middle East or UAE for that matter?
Yeah, I mean, just on that, for my part, and certainly looking at it from an English law perspective, I'm not sure it would matter if you were in the country next to Russia or the Ukraine who wants to use a clause like this to get an increase in the price. Because I think certainly looking at it from an English law perspective and how an English court would interpret this clause, I think that they would take the proximity as indicative of the fact that you're looking at boots on the ground consequences of the war. So, for example, if you have to bring in a big amount of rebar and it has to go, the only way you can do it is by road, and there's a war in the country that you have to drive through, it may be then that you could say, you're going to have to pay me additional money to fly this in because I can't bring it through this country because of the war. But I think because it's trying, in my interpretation of this clause, to tie the risk to proximity, it's talking not about sort of economic consequences of a war, but the practical consequences. And I think if you look at what the employer has to pay under this clause, increased costs or incidentals for the execution of the contract that are attributable to or resulting from the war or war risks. Again, I think what they're talking there is things like the extra cost of bringing something in via a different route, rather than, for example, the economic consequences that just so happen to be affecting you because you happen to be near, when if you were in a different continent, you may be similarly affected. That would be my thoughts on from an English law perspective.
Emma, would you like to add to this particular question that Rohit has posed, which is very interesting?
I think it's a really interesting idea to explore that concept of near and the concept of, a nexus, the proximity to the economic impact of an event. This is a long established clause or similar clauses that we see in our contracts. I've only ever seen it used in circumstances that Camille has articulated. And I think that if you were starting again, I think you would want to include wording to cover the exact scenario that you're talking about, which then always leads me to think, well, if that wording isn't in there, then the conclusion of a tribunal construing those words would be talking more about the physical proximity. Yes, please.
Would the war also include economic wars or only the sound and light stuff? In this case, this definition. When a blockade is announced.
Yeah, I mean, again, I think that you need a proximity and you need a cause and effect, don't you? And I think always the causation element of this discussion is really the tricky one, because quite often it can be difficult to actually demonstrate that costs arose, material costs, for example, rose simply by virtue of the war, and were there not other events and issues that actually were the real cause of the increase in prices.
There is an example in the recent past, right, when Qatar was actually blacked out by the other countries and there was no import-export possible. The persons who were executing the works there were to probably rearrange the entire supply chain. And therefore, the
I think also on this particular clause, and obviously, as Emma's already said, every contract's going to have to be construed on its own terms. This does provide an explanation of what constitutes a war risk, talking about war hostilities, warlike operations. So it's certainly not impossible that some sort of blockade might be properly characterised as a warlike operation. Whether that gets you more money is a complex question that's going to also turn on the facts. But as I say, I think it has to be because of the proximity of the site to the war or the warlike operations, rather than a global consequence of that war or those warlike operations.
So with this, we move ahead to the next slide. We have covered the FM related aspects. Now, this is again a very common clause. We all are aware. It is variation. So again, this is an extract from one of the recent cases that we have dealt with. It states that variation means a variation to quantities, quality, or other characteristics of any aspect of works or the requirement for the works, which may include acceleration, deceleration, sequencing, change, modification, substitution, addition to, or reduction or omission thereof. Now, the below condition A and B broadly states that the contractor would get time and cost both if it falls under the overarching clause wording. Now, I would like to ask Matthias that can the price changes emanating from market turmoil be claimed under variation in this type of typical clause?
Well, I think, Mark, from my sort of understanding of how these sort of variation clauses work, I would say the short answer would be not, or at least very unlikely, because when you're dealing with the variation clauses, for all of us who have dealt with these sort of construction contracts on a day-to-day basis, they are quite standard, sort of typical, almost boilerplate variation clauses that you find in almost all of the sort of standard form contracts, be it FIDIC or you're operating more in this jurisdiction, JCT, NEC contracts. And they all sort of have one common thread, which is that they deal with a change in either the scope or the standard of works which is specified in the contract. So just by virtue of the fact that there may have been an issue with sort of price fluctuations or a change in the costs of obtaining or procuring certain materials or certain resources for a particular project, that doesn't itself amount to a variation of the contract, as I understand, I think, and as probably most sort of common law tribunals would understand it. I mean, I have come across a few cases before where a contractor has tried to claim, for instance, I was in an arbitration, I think, in Hong Kong a couple of years ago, where there was a change in the source of the materials or where they were procured from, and therefore a sort of consequential change in the cost of the materials as well. So in that particular case, I think we were talking about ceramic tiles, and the contractor actually was, they tendered and they basically put forward a tender price on the basis that they would get the tiles from China, which would obviously reduce the costs. But in the end, they had to procure the tiles from elsewhere in Japan, which basically tripled the costs. And they tried to bring that as not so much a cost fluctuation claim, but as a variation claim, because they said that there was a change in the standard or the quality of the work or the materials being supplied under the contract. And now, unsurprisingly, that didn't succeed in that arbitration for a very simple reason. So the arbitrator basically said, look, you have a standard of work, which is basically just a generic standard of a particular type of finishing for ceramic tile. It doesn't specify where that tile has to come from. So just by virtue of the fact that you couldn't source it from the country of origin that you had in mind when you tendered for the project, that itself didn't amount to a variation or change to the contracts. Now, had the specifications of the works or the employer's requirements actually specified a particular type of tile, for instance, from a particular country, for instance, and then the architect or the contract administrator changed that afterwards, then that might potentially be an arguable variation claim. But barring that sort of scenario, I would say generally it would be quite difficult to try and squeeze yourself into a variation clause like that, despite price fluctuations.
That's correct. But supposedly, because of market turmoil, this particular event is happening, that I'm sourcing some material from China rather than supposedly I envisaged from Italy that I'm going to source some material from Italy, which would have costed me less. And now I'm sourcing this from China, which is costing me more. And this is because of the market turmoil. What does the contractor do in such situation? He needs to put his case in the right manner, maybe under this very clause. So, Kemal, would you like to put your thoughts on this?
Well, I think, as I said, it does come down to this particular clause, and it's the capital W works, and that is the end product works. But I think in reality, it's not always in an employer's interest to stick to the strict letter of the contract. And in fact, quite often the contract's put in a drawer and brought out at the end if there's a dispute. And if it is significantly more difficult for a contractor to procure a particular material, then that gives you an opportunity to negotiate with the employer. And it may be, if there is a particular difficulty, that the employer is forced to impose a change on the contractor because they are not content with the solution that the contractor is offering, or it's taking too long for the contractor to put the order in because they can't pay the advance payment, for example. So in a situation such as that, if that drives the employer to take charge of the situation and say, right, in that case, go get that from there, that automatically instigates a change. And ordinarily, that change would bring with it the clause on variations and the time and money. Of course, then you run a risk of the employer saying that their response in saying get this material from somewhere else was not a variation properly so called, but an instruction because the contractor was in breach. So there's a whole nother dispute you've opened up there. But I think the key thing is this clause, and as we said previously, might give you a foothold to say, well, what are you going to do about it? The only thing you can do, employer, is give me an instruction. You give me an instruction, you open the door to variation. Is there somewhere we can meet in the middle?
Rohit, have you come across a situation such as this?
Yeah, so the claim which I was talking about, every nook and corner of the contract was used somehow to support the claim. So there also, the suggestion was try to put in under the variation. How it was, tried to put under variation was that because of the market turmoil, there was kind of a delayed delivery which was happening, and now the employer was wanting to have certain portion of the project ready, by certain date, and because of the because of these delays which were happening because of this Russia-Ukraine war, things were not meeting the timelines which were there, as per which the employer wanted that portion of the refinery to be delivered. And accordingly, then there was a kind of a, I would say not an instruction, but a suggestion from the employer that explore alternate options which were there. And that's how, the contractor, tried to put in one or two of the long lead items under this clause, saying that you told me to buy it from other sources, primarily because of delays which are caused because of the market turmoil. So I'll try to treat it under the variations. Now, still the discussions are ongoing. I'm not sure how strong legally and the submission will be. But as I said, practically speaking, what is happening in the industry is that the contractors are suffering because of this price changes and turmoil in the market, both from time and cost perspective. Now, whether an employer takes a very stringent position, ignoring the impact of such turmoil and just leaving the contractor in lurch, or an employer is taking a practical position to say that, okay, I may consider some portion of it, is what is is kind of an issue or a decision which an employer and its engineers have to take. But in reality, lots and lots of these things are coming up where contractors are suffering because of massive changes which have taken place in the last few years.
To be fair, I mean, I've been working on projects where the employer has been happy to engage in that discussion, because actually, from an employer's perspective, they need their facility to be up and running in order to make money. Yes, and actually, depending on which way your currency fluctuations are going, and if you're exporting the product, they could be making more money sooner rather than later. And so there is room for those kind of discussions, but I think that contractors have to understand that they are starting those discussions from a very not actually based on contract terms themselves, but actually just appealing to the commercial nature of the employer and the what's going to be good for the project, what's going to be good for the employer, what's going to be good for the shareholders of the employer to actually make this facility work and work well.
That's good. So Emma, you have rightly covered the employer's perspective also. Yeah, that is really important. So coming to a slightly different topic, although it is related to this, but it is related to quantification of losses. I think, Rohit, you're the best person because you're the expert and you have been witness as you have appeared as an expert witness in matters such as these. But before I dive into the quantification, I have this question to maybe Emma. What role does expert testimony typically play in price escalation disputes?
You see, now how I use an expert is to actually utilise the formula so that no one is looking at me to fill in. I think maybe you've got a slide with the formula on it. So certainly I would be looking for someone a little bit more mathematically minded than myself to plug into the formula. Sometimes, and actually in more seriousness, you could well use a quantum expert for a more broader perspective on what's happening globally, what's happening in the market for a particular item. You could well find that your price escalation formula doesn't cover all of the costs that you are actually concerned about now. And again, that means that you've taken the risk of that particular cost increase. You therefore need a lot of help to persuade the employer owner that actually they should be supporting you with that cost, and they will want to. And again, it comes back to the point I was making before. They want to try and understand as much as possible, because they have people that they need to answer to internally, that the reason for the cost is because of market forces, because of the war impact, whatever it might be, and not simply because the contractor has not managed his own supply chain properly. And I think you can use an expert then to input on those type of considerations about what's happening more broadly in the market very usefully.
Yeah, that's correct. Coming to Rohit, what steps do you undertake to assess the losses if the price escalation formula, like Emma just mentioned, for specific components provided in the contract does not cover the same?
So Emma rightly said, the best option is to use the price escalation formula. But in a scenario, and I have been in that scenario, like the formula which you're talking about has got certain components which are covered, and not all of them. And because of this turmoil, the formula was not able to, compensate the contractor to the extent of its losses which were there because of the market turmoil. So my first option is, if the formula is there, well and good, give that option to the tribunal or your client. And in case the formula is not compensating and you want to have an alternate position, then I would like to go in for my actual loss assessment. But calculating actual loss in this case is quite tedious, as Matthias said, for many reasons. Like, for example, let's assume we have to order in an oil and gas project, a boiler. Now, in the original baseline schedule, there was certain date on which the boiler was to be ordered. And then accordingly, the contractor might have estimated the price of the boiler in its original, tender price, if it is a lump sum EPC type of a project. Now, supposedly, if that ordering date as per the baseline is prior to the market turmoil, and then the ordering is delayed and it gets into that zone of market turmoil, then we need to see what is the reason for that delay. And then again, a small critical path and a delay analysis has to be done on that specific equipment to find out who is responsible for delay. Is it the contractor or the employer? Because the employer might say that, look, as per your original schedule, you were to order this when everything was hunky-dory, no war was there, and then why should I compensate you? Now, if the delay is because attributable to the employer and the analysis shows that, then the issue comes is, how will you calculate the quantum of losses? Because there is some bit of money, let's say $100 is the price which the contractor has considered in its original tender price. Now, because of now it may be that the $100 is an estimate which has been taken by the tenderer, by the contractor, which might not be the actual price. The actual price, removing the impact of any market turmoil, could be $120. Now that $20, which is the difference between the estimated price by the contractor in its original bid price, vis-a-vis what is the actual price, removing the impact of the turmoil, is $20. Now that $20 is not attributable or cannot be claimed to the employer. That is something which is a normal risk or a normal increase or a normal inflation which has happened in the price of the boiler, nothing to do with this market turmoil. So what you need to do is, first of all, you need to find out what was the estimate. Then you need to also find out what is the price at the time when the baseline schedule said that the procurement will happen should have been the price. Now, in case the procurement has been delayed because of employer and it goes into the market turmoil zone, then you need to see what is the actual price at which the equipment has been ordered. And then the difference will not be the base estimated price in the tender versus the actual price. It will be that price at which the equipment could have been ordered as per the baseline schedule, considering that the employer delay is there, vis-a-vis the actual price which is there. So all these 3-4 components have to be seen. So it's a complicated mix of in reality, it has never been a situation where a contractor has been able to order the equipment as per its original baseline. It could be many reasons. So you need to find out what is the difference at the actual price vis-a-vis the base tender price, vis-a-vis what could have been the price at the time of ordering. Then another important thing which needs to be taken into consideration is, a lot of times in complex oil and gas and other power projects and all, the specifications which might have been used at the time of tendering, which the contractor might have considered, vis-a-vis the actual specifications might be different in terms of size, material, etc. So those issues also have to be taken into consideration. Then there is a normal inflation which would have happened. Now, a credit for that normal inflation, which was originally part of contractor scope, also needs to be given. So it's a complicated mix of all these things based on calculating the actual losses. And I'm just giving you a broad guideline, but it's not an easy job. That's what I can say.
Thank you, Rohit, for this. Now, coming to a slightly different topic, although related, it is the currency fluctuation. Emma, you have already touched, but this is just to deep dive into the currency fluctuation. So especially at the time of Russia-Ukraine war, we see ruble going down vis-a-vis a USD or euros, etc., or Chinese yen. Now let's take an example. If the currency of the country where the project is being executed depreciates, it is certain that the cost of imports will rise, potentially causing a sudden increase in the project cost. What are potential solutions for the contractor and the parties involved? So maybe, Kemal, would you like to throw some light on this?
Well, I think the first starting point is what is the currency of the contract? And some contracts, particularly sophisticated international contracts, will have a payment in various currencies. So it may say 10% of the contract price is paid in US dollars, so much in euros. And obviously you have to start always looking at the contract and see what the position is there, because it may be often in the course of contracts, people assume a way of working that's not necessarily actually quite accurate. And when you look at the contract, there may be some form of relief there. Another thing that you can do, and I've seen it attempted, not necessarily successfully, but is what currency you claim your losses in an arbitration. And so I've seen a recent example of a case where part of the claim was, because of the delays, I was purchasing things in my native currency, which devalued against the currency of the contract. And that is a loss associated with the delay, like we were discussing just now, fixing a loss to a delay rather than just to a fluctuation. And we therefore want to include within our claim a currency loss. But I think it is obviously, as with the price escalation that we discussed, if the contract provides for payment in a currency, then that's usually going to be accepted as the contractor's risk, or potentially the contractor's benefit, depending on where they're purchasing materials. I think the starting point, as much as you can, is to try from the outset to peg your prices so that you know what your risk is from a currency perspective. So pre-ordering materials, for example, at that fixed currency rate, and you can, in a big sophisticated contract, there is room for hedging your risk, literally through the purchase of currency, advanced purchase of currency, you've pegged your risk. So I think where it comes to currency fluctuation, because you can purchase currency in the market in a different way from purchasing equipment, because obviously equipment potentially people are going to want to take it. Where are you going to put 12 tons of rebar? Whereas it's a paper transaction. You can advance purchase a currency and seek to protect yourself against that risk. And that's a useful thing you could do from the outset. It's a bit late often when the currency goes pop, but that's something that you can, and it's really worth thinking about just outside the contract. Can I hedge my risk by purchasing this currency in advance, or indeed make a sort of financial transaction that if the currency falls, you've bet against the fall, you get the money back. So that's another way of doing it, particularly if your employer is wedded to a particular currency. And if, for example, you're transacting with a government, many governments insist upon payment in their currency, as you might expect. And therefore you may have to transact in a dodgy currency, but there may be things you could do outside the contract to protect that risk.
Yeah, I agree. And I mean, actually, there's a recent sort of case, a non-construction case, quite a well-known case in this jurisdiction, which went all the way to the Supreme Court. A lot of you might have heard of it, which is RTI and MERS shipping, which is a bit of a sort of comparable scenario where it was a contract about shipping. So it was a contract for freightment, and there was a particular clause in the contract which requires the freight to be paid in US dollars. And then one of the sort of the charterer, because it's a Russian company, quite a few of the subsidiaries got sanctioned by the US, not itself, but it got sanctioned by the US, and they couldn't basically get any sort of enough US dollars, at least not without making a huge loss in terms of currencies and all that. So they tried to use a force majeure clause under the contract to say that, well, quite interestingly, they weren't relying on the force majeure clause to suspend the contract. Rather, they were saying that because the force majeure clause requires the parties to use reasonable endeavors to overcome the situation, they can somehow force the ship owner to accept payments in a different currency, in euros. That was originally in the Court of Appeal, that was upheld. That argument was sort of upheld. But then when it went all the way to Supreme Court, basically Supreme Court said, look, that's what the contract says. That's the contractual currency for the payment. That was the parties bargained for. it would take really clear words for the parties to be able to sort of move away from what was bargained for and to basically have to accept non-contractual performance. So that, I think, is just a cautionary tale. You know, so it's basically what reinforces what Camille says, which is that you need to think about the risk way in advance. I mean, there are some contractors who, because they do so many different international projects and they have sort of payments being received in so many different types of currencies, you know, US dollars and all that, maybe that by virtue of the payments that they receive in certain other projects, they'll have enough to use that sort of currency to pay for certain materials on another project in a particular currency. And that almost hedges it a little bit. But save for that sort of scenario where you're that type of sort of big sort of multinational type of sort of contractor, you would need some form of sort of currency swap or hedging sort of arrangement in order to really sort of protect yourself against the risk, particularly in this sort of climate, and rather than just rely on what the contract might or might not do for you later in the day when a dispute arises.
Yeah, that's correct. Rohit,
Just to add
Yeah.
over here, you see, look at this graph. The peak is somewhere close to around July 22.
that's all.
And the peak is close to, I think, around ruble versus US dollar, if I see, is around 60 or maybe around 55 or so. And then you see how the graph is declining on a very steep basis. And this is one of my cases also where I'm having this issue. The dollar versus ruble or euro versus ruble has declined drastically in a matter of 2 to 3 months. Now, my case is that there is one of the European suppliers supplying a complicated equipment to a Russian party. Because of this Russia-Ukraine war, the contract got, was terminated. And now the original contract was in rubles. Now, but because the initial things was ruble versus USD was more or less stable prior to the start of the war. But imagine the fluctuation which has happened in a matter of few months. The date of termination has become extremely important in order to calculate the damages. So if the damages are to be calculated in the original contract price, which was rubles, probably a ruble was worth $60 at the peak stage, while before that it was close to around $120, because if you see the starting point is $120. And then at the time of the war, it was close to around $60. So almost there is 50% drop in the value of that supply in terms of dollar by a supplier who is probably American or a European vendor. And then it has then suddenly dropped down to close to around, I think, around $80 or $85 or $90 or so. And there also the most important thing is what is the date on which the claim is going to be prepared or the termination is going to happen. Because a shift in the date of termination, a shift in the date of damage calculation immediately changes the value of the claim drastically when it comes to US dollars.
Emma, would you like to add something?
Yeah, the only thing that, so again, in terms of managing the scenario, we've been talking a lot about, I quite agree, in terms of hedging price on those projects and that your contracts you might well have an onshore offshore portion, or for long lead items you could be paid in different currency. I think also it's worth considering about your broader supply chain, because you may well be able to manage items that are not long lead items. So if you have flexibility, for example, in your contract chart, the supply chain that allows you to switch to a supplier that's in a different country, and therefore that might enable you to mitigate what you're otherwise seeing here. And of course, then you need to look carefully in your supply contracts. You want to ensure that you've got termination provisions that give you that flexibility. You might also, with your favourite suppliers, you could come to a deal with them in terms of, I don't know, if you're bulk buying widgets, that you could get a good price on them. Anyway, I think there are a number of things that your procurement team would probably be able to help you with here in terms of mitigating the impact of these prices, these price fluctuations.
That's true. Now with this, we come to a slightly different topic. Maybe this is the last topic that we are going to touch. It is consequential losses. There is no slide as to this particular topic, but again, this is related to market turmoil. So we can discuss a practical example. Supposedly, a project is delayed, and it is an established position, an agreed position between the parties that the delays are attributable to, let's say, employer. Now, during the extended period, a situation of market turmoil occurs. What are potential solutions for the contractor in such a situation? Kamil, maybe you could throw some light.
Well, we've touched on it a little bit already, and I think you start from the proposition that most contracts will provide, in the event of an employer delay, you're entitled to your associated compensation. And it's important to think about that compensation in the broad sense. And I think it's right, as we've discussed, that if, as a result of an employer delay, you're unable to procure something at the price that you intended to procure it, then you would argue, well, it's not the market fluctuation that's increased my price, it's your delay. And then you get into arguments we've already discussed about whether your original contract price was sufficient. And as has been clearly explained, and I entirely agree, it's not just how much more than you thought, it's how much more than you should have thought. But then, even then, there's arguments about whether there's going to be arguments about whether you mitigated that delay, whether you ought to have foreseen, for example, that you weren't that concrete was not going to come to site for a year, and maybe pre-ordered and guarded yourself against that risk. And that's all well to say, but this is likely to be happening at a time when you haven't got the assurance that the employer is going to accept or ultimately be held liable for that delay. And what do you do? And I think one of the arguments you might be able to say in those circumstances is it's all very well to say I ought to have purchased this and foreseen this. Where's the magic money tree? So I think in terms of employer delay or the consequence of employer events, like we talked about earlier on in instruction, that is really quite fruitful ground for potentially recovering, not necessarily market fluctuations, but price increases because of delay. And I wouldn't necessarily characterise that as a market fluctuation, but as you say, a consequential loss flowing from the employer delay event.
Matthias, would you like to add something to this?
Yeah, no, I agree with what Camila said, and I've certainly seen claims being sort of put as part of a loss and expense claim from a contractor, and yes, I mean calling it sort of price fluctuation almost sort of masks what it really is, because it's not really about sort of just inflation or fluctuations. It's really about the consequences of a delay event, which we say would be attributable to a non-culpable delay event, possibly an employer's prevention event. And I've certainly seen arbitral tribunals being a lot more sort of receptive to the idea of entertaining such claims in the form of a loss and expense claim. I think that's more of a matter of principle. And then what frequently happens though is that sort of the parties don't think enough about how you want to evidence that cost, and also sort of bridging again that all important causal link between the delay and the actual price increase that you're trying to claim. And it's really at that sort of evidential stage, that quantum stage, where most parties trip up, because it's all well and good to say, well, yes, obviously, you know, we couldn't procure this at a certain time. We've only done this now. Costs have changed, but there are so many underlying assumptions that sort of Rohit's very sort of rightly put. You know, the calculation of the actual loss that is attributable to that delay is actually quite complicated. And if you don't do that properly, then more often than not, even if you might win on a principle, it's a bit of a sort of Pyrrhic victory, because in the end, you're not going to get any money out of it. And that's what I've seen happen quite a lot of times, because when you're dealing with a massive delay-related claim, particularly in a project which is so sort of complicated and affected by so many different factors, I think parties sort of almost run out of steam by a certain point, and then they deal with all the prolongation costs, they deal with everything, which is sufficiently complicated, and then they get to the fluctuation, and like, okay, well, let's just do a 10-pager on the quantum report, and that's it. And that's what frequently sort of gets sort of people tripped up. So I think getting sort of the evidence, all sort of your ducks in a row almost quite early on, and making sure that you also have not just there's the quantity surveying bit, which is obviously very important because you need the expert evidence on that, but the documentary evidence that goes behind that as well, in terms of, you know, what went into the tender pricing, any quotations that you've got from suppliers and all of that at the time. All of those sorts of things will be helpful, because otherwise we just leave your expert basically groping the dark and dealing with a bit of a speculative claim. And that's the last thing you want. You don't want to give the impression to any tribunal that you're basically speculating.
That's
And I think that's key.
Rohit, do you have some real life examples on this?
Yeah, so as Matthias said, it's very complicated, for a quantum expert to quantify such kind of things. And many a times, contractors are not having the information of the bid stage. They probably might not be having those kind of, quotations and on offers from the vendors where they can say firmly that this is the price which I have anticipated at the stage of bidding. Also, many bidding strategies are there. So, contractors might not be very keen in sharing their inside bidding strategy and bidding information to the tribunal or to the quantum expert or to the other side. So in one of my cases, what is happening is the contractor is not interested in sharing its pre-bid information at all. And it's not interested in also giving me an access to their accounting systems, ledgers and all. So there we have to find other way. The other ways are what we are doing is there are indices within various markets, European indices related to manufacturing of tanks, manufacturing of materials like boilers, steam turbines, etc., pumps, etc. So you are probably going to those industry specific indices to see what is the way these industry indices have been going up and down during the area or period when the turmoil was there, and then try to indicate and give not an exact quantum but a broad idea of the quantum at what is the loss. And the fact remains is because if the contractor is not keen in sharing the actual information or is not having it, then what is the alternative? And then tribunal probably are being told that the situation is that you cannot share the inside information. These are extremely confidential information and it based on the competitive strategies of the contractor. So then the alternate is just try to look at the various indices which are there prevalent, try to mix the indices. So if you have a steel indice and a particular tank is there which is almost having 70% cost associated with carbon steel, and you have a carbon steel indice from London Metal Exchange, then you try to use that indice and then calculate how much could be the potential loss in our equipment which has 70% value coming from carbon steel. So that's a bit complex, but I agree with Matthias what saying.
Just on that, just as a word of caution, in any assessment by a quantum expert, there always comes to these sort of claims, perhaps you might unfairly characterize them as the rump of claims at the end that doesn't have the information that you would ideally like. And you have to be careful not to damage your credibility on other claims where you have got good information by what might be characterized in cross-examination, for example, as dreaming up losses that don't exist. And I think it is important to balance and doing your best to come up with an answer to a question to assist the tribunal with just thinking about how far you can go with that analysis without undermining your credibility. Because if your credibility as an expert is lost, then your case is lost. And I think using material that's available, like indices, properly pegging it, getting the supporting information, if you're going to have to do a approach that's not based on primary documents, is really important, because it's so easy to say, well, it's about 10%, it's about 5%. And once you've done that, your other claim, which was originally quite a good claim, is lost because the tribunal has lost confidence in you as an independent expert.
Emma, this is the
Yeah, I mean, the only thing that I would say, and again, it does require a little bit of gymnastics, is thinking about this whole concept of commercially sensitive information and not wanting it to be seen by other people, and to what extent could you disclose that information by putting certain protections around it. So, for example, I have seen tribunals view such information just like they would, let's say, privileged information. They make a determination, they would see it, it's kind of for your eyes only, and say, I have satisfied myself. I have also seen a tribunal engage an expert separately of itself to deal with sensitive information. So I think there are ways that need to be explored and to run down those ideas before you arrive at the conclusion, this is commercially sensitive information, therefore I'm not going to rely on it. Because I think you need to try, you do need to try to work out a way of actually being able to justify your case. Because as we said, indices are all fine and well, but if you have the actual evidence that's going to support you, then that will always trump indices.
Yeah, I agree. I mean, practically, I've just been in an arbitration where the parties, so they have sort of counsel from both parties and their legal teams and tribunal and possibly one or two of the experts. They form part of a confidentiality ring, and it is saying this, they basically sign almost like a non-disclosure agreement and all of that, and then they have a protocol in place where different sort of members of each party's teams will have different access to different versions of the bundle, and with some members having greater access to the sort of bundle with the confidential sort of documents. So it's doable,
Exactly,
actually. And
yeah.
and having that in place, actually, I mean, ultimately, obviously, it's a bit of a commercial decision for the clients as well. I mean, they might think that, well, you know, I'm just not going to run the risk of this. So in which case, it might be a question between keeping a claim or dropping it.
Exactly,
Yeah.
exactly. Yeah, I completely agree.
Yeah, that's enlightening. Now, one closing question to all the panelists, and maybe a one-liner would do. How do you approach negotiation strategies in price escalation disputes, particularly when parties have different interpretations of contractual provisions or market conditions? Maybe a one-liner from all the panelists.
Okay, well, I would say it's never in an employer's interest for a contractor to go bust.
Yes, I would say having a complete project at some point is better than having no project in the end. So
Yeah,
pretty much the same message.
that's a positive. Emma?
Yeah, I mean, I would say pragmatism and fairness. If you're going into these kind of discussions, you need to be well prepared and to understand, you know, the putting forward a credible claim means that you take off the table all of the incredible claims. Yes, so you are left with having a justifiable spreadsheet where you can go through and you tick everything off and you go, look, I'm not, you know, I'm going to take the hit on these particular items, but these are the ones that I want to discuss with you because these are the ones that I think, for all of these equitable reasons, I think that we should be sharing. Or, you know, there's some kind of degree of pain gain arrangement that you can come at. But the idea that you can just shove it all to one party or the other party could shove it all to you, I think you need to be able to approach the discussion in a more constructive way in order to achieve a resolution that you can all be happy with.
Rohit?
Yeah, I would say both the parties have to look at win-win. You have employer needs project, contractor also needs project and to make some money out of it. So a win-win solution is most important. And that's something which both the parties should aim at.
So with this, we come to the end. We have some 10-15 minutes left and I would invite questions from the audience. Anyone? Yes. Can you just spell your name as?
Sure, this is Charge. I'm coming from Istanbul, Turkey. So actually, I'm having the civil law background, so which is a bit different from the, of course, the concepts that we have discussed today. But I think what I'm going to ask is actually a supplementary question to the last question of yours. So it would be, I think, to the all panelists. I think since we have the English law experts, they would be able to elaborate on this matter, because if it's the market turmoil is happening in a contract when it is governed by a civil law jurisdiction, be it the Gulf region countries, any of those, or maybe some of the continental European countries, then I think the overcome of these effects of this market turmoil is rather easy because we have the concept of hardship, which is in not only in the Union Law principles, but in most of the civil law jurisdictions is a part of the law system. So the question is, of course, and I think in India there's highly criticism about this point. It's a common law country, yes, and Indian law by application does not include the application of hardship principle, but the criticism is since everything has changed and the contracts are need to be adapted to the changed circumstances, first the courts shall adapt themselves to the changed circumstances. In that sense, for instance, if there is a dispute arising from a contract whereby it is governed by a common law jurisdiction, is it possible in an arbitration to suggest that application of the soft law, as we call it, markatoria, unilateral principles, for instance, is it possible to really apply the hardship principles in that scenario? Is there a loophole in the English law system whereby we would be able to apply the hardship in order to adapt the contract to the changed circumstances? So maybe that's the first question. And the second question is also a supplementary question with this one. And this is especially related with the mega projects whereby there is the main contractor and there is the subcontractors, but it's not always easy to keep the same applicable law to the subcontractors, although we say, I will pay you if I get paid, pay if paid clauses, which is also highly controversial in legal environment, whether they are valid or not. So the main contractor is exposed to an additional risk that if the main contract is governed by a common law jurisdiction, there will be no adaptation, so there will be no price escalation eventually. But the subcontract agreement might be governed by a civil law jurisdiction, whereby the subcontractor will be able to adapt the contract to the detriment of the main contractor, which would be an additional burden for the main contractor. So I don't know, if there's any solutions to that one, I would be very much happy to hear that. Thank you.
Well, I think we talked a lot about things from a contractor's perspective, and obviously hardship is likely to be one of the best arguments for arguing for price escalation. But I think sometimes it's worth just pausing and thinking about some of this from an employer's perspective. And hardship cuts both ways. And if, for example, you contract with, particularly with government, but not just governments, often an employer has a budget for a project and they've committed the investment in the project, got it so far with an expectation of being able to realise that project for a particular amount of money. And one of the problems with hardship is you're just transferring a hardship sometimes from the contract party who accepted the risk on one view to the contract party who thought they safeguarded against the risk by contracting for a fixed price. So I think that hardship, and we talked when we were paying for this, we talked a bit about just jurisdictions with good faith and similar concepts that might be used to sort of softer law, as you rightly say, to where the black letter of the contract doesn't work. And I think that's really fruitful ground. But when you're looking at something like hardship, the tribunal is going to be particularly thinking about balancing the interests of two parties. And if you save the contractor from hardship, and you can see how a main contractor might suffer particular hardship in your example, you might transfer that to the employer. But if you've got a subcontractor who's in the middle, who's both got the detriment of the position of the employer and the position of the contractor, he's cutting it both ways. On the one hand, he thinks he's got a fixed price. On the other hand, the employer thinks they've got a fixed price. Then there might be a bit more room for saying the hardship is concentrated in a particular place, and certain law jurisdictions will find a way to assist that. But again, it's always important when you're thinking about things like hardship, good faith, and similar concepts to just pause for a minute and think, what about the other side? How is the tribunal going to balance our respective rights?
Any other questions? Yeah.
What I wanted to understand was if there is already a no escalation clause in a contract, how does any of this help? What is the success rate worldwide? Because in case there is a delay, the employer is very happy to invoke the LD clause. Or the communication between the parties make a difference while the contract is on. And while it has not gotten into litigation, mostly arbitration.
I mean, it draws, you make very good points. Here, a lot of the perspective of the discussion here is kind of was the idea of a lump sum contracting, yes, where a contractor has taken on a turnkey EPC style risk, to build a facility of some sort to a piece of civil infrastructure. And the English law is brutal. If a contractor has taken on that risk, it doesn't matter how much hardship and good faith that the contractor might want to wave his arms around and say that English law will not help them. The courts have always made it abundantly clear that they are not there to give one party a better bargain than they entered into. Practically speaking, we have seen, and actually I've seen more movement in the past, well, really through COVID and more recently, with the price fluctuations, the currency fluctuations. I have seen employers engaging in these kind of discussions with contractors to share the cost implications far more than they ever did during the global financial crisis. I think the impact of the global financial crisis was so radical that no one was prepared to discuss anything, and employers just walked away. Whereas now, no employer wants to be that guy anymore, or girl. They don't want to take that position. That is not how the ethos of global business is working anymore. You don't want to have a reputation like the big banks had. Yes, so that's why, and following COVID, there was a lot more. I wouldn't say it was in every case, because I know a lot of clients who've really struggled with the impact of COVID and feeling that they have borne the brunt of it. But there has been a lot more discussion since the Russian-Ukraine war, supply chain issues that everyone acknowledges are very volatile at the moment. And there is a lot more movement now. That's all I can say. I mean, I can give you specific examples, but that's.
So I thought because COVID, it's been 3 years, 4 years down. So there could have been some precedents, and maybe the courts also upheld or decided to set aside those awards. Because there's no love loss by an arbitrator. He still has to go by the contract.
No, indeed. But again, during, with COVID, a lot of instances, you were able to shoehorn, contractors were able to shoehorn their claims within the force majeure provision or within a change in law provision, depending on the circumstances that was impacting the project, yes? And the way that projects were being impacted, it was because, sites were being locked down, or, there were issues about, movement around site, how many people were allowed to even be on site at the time. There were fairly concrete examples that people could use, and arbitrators would uphold that. I think really from the contractor's perspective, really, they felt aggrieved at having to go all the way to arbitration to actually be able to get that type of relief, whereas really it should have been understood that relief was available. There's always a question about, well, what's your actual cost, and again, it's this distrust between contractors and employers, isn't it, which again comes from the adversarial lump sum contracting method.
Just to add on, you see there again, as we said in the last question, practicality, pragmatism is important. If you see this price escalation graph, the first graph, January 22, the price of 1 ruble was, just go to the price escalation. The last currency fluctuation, yes. On January 22nd, 1 ruble was equivalent to, or $1 was equivalent to 120 rubles. And in a matter of 3-4 months, $1 was equivalent to 60 rubles. So there is a price change. Let's say if a contract is 1 rubles, a supplier or $1, the supplier has lost almost 50% of the price. Now, in such a situation, the question in front of the supplier is, should I continue to be there in the contract because I have got provisions of the contract like no price fluctuation is going to be paid and all that, or what should I do? And if I continue to be there in the contract, then the supplier will think either I lose and I meet all the conditions of the contract, or I go and request the employer, please help me out. This is something which I had not, brought into my price bid. So that's where the practicality comes for both the contractor and the employer, that how to resolve this issue in the benefit of the overall project objectives. Now, yes, there are employers, as Emma said, might take a very stringent stand. No currency fluctuation is allowed. Go and you have to deal with the situation. But many of the important projects and employers are taking a stand. Okay, let's engage. Let's try to see what best can be done, and let's try to be flexible in terms of resolving the issue for the benefit of the project objectives.
So it would be right to say the profit margins are anyways not beyond 10 to 15%. So a 50% decrease will
Eradicate your
certainly-
profit. Yes. So basically,
termination could be more fatal.
so
Termination by the contract.
yeah. So that again, I think legally you'll have to decide that
Yeah.
supposedly if you terminate the
not into
contract,
that.
then what do you do?
Yeah.
Do you pay more than $35 which you have lost, or what do you do? That I need
Well,
to-
I mean, to be fair, I have had a contractor terminate at a fairly early stage of an extremely challenging project because there was a cap on the contractor's liability, and actually they thought, well, I'd much rather be exposed to termination claims up to the cap than carry on this hopeless project for the next 8 years, and it's just money being chucked down the drain. So, but anyway, but my usual instance, if someone says, "Oh, I want to terminate a contract," I go, "Well, hold it a second. Let's just let's regroup and think about this." Yeah.
But actually, that is not a bad point. It is worth looking at what your overall exposure is in a termination event. And if there's no cap, it's almost always going to be better to carry on, because whatever the employer is, if there is an additional price that you're going to have to pay if you carry on, if you don't carry on, the employer is going to have to pay it, and you're going to pay it anyway. So ultimately, you're going to be hit with this loss almost regardless of whether you carry on or you don't carry on, unless, as I said earlier, unless you go bust, because that is the difference in what you're doing it for and what it actually costs is going to equate to the employer's loss. It might be that your loss is better off passing your losses, earning some money elsewhere and paying that money over. But if you do have a contractual cap on your liability, then this is not legal advice, by the way, then it might be worth taking some advice about whether you're better placed to terminate. But in the absence of a cap, you're almost never better off terminating.
And you have reputational risk.
Yeah, absolutely.
But I think equally employers have reputational risk as well, right? Are they really going to be one to known as the employer that that pins the contractor down every single time for provisions that might actually, in terms of fairness, be reasonable for the contractor to take, because they lose that contractor.
I think one point on indices, we talk about indices all the time, but of course there's a real problem with indices, which is the enormous time lag before the indices come out, which therefore suggests the importance of actually having those records going very early to the employer, saying this is my actual increases here.
I've never, in all my career, ever said to anyone, "You've kept too many records."
No.
I mean, sometimes people have kept records that reveal that they haven't covered themselves in glory, but that's not about the quantity of the records, that's about their content. Always, for a quantum expert and for any claim, real documents that your expert can look at and say, "I've looked at this and I can tell you X, Y." It's really helpful to keep records, but also just think about what you're writing on WhatsApp.
Can I just pick up one point there? I think there were 2 points to me that came out of the discussion, and that is whether we're preparing for claims before tribunals and proving causation, or whether clients are getting together and trying to find commercial resolutions to these situations. There seem to me to be 2 big things. One was the communication, which Emma, you picked up on, and I agree there seems to have been more engagement on both sides, particularly employer and contractor, since COVID. The other point was the record side of it, which I know as disputes lawyers, we're always banging on about good records. But I was just interested to see or to hear people's views on whether, given the turmoil over the last 3 3 or so years and all of these issues, we are generally seeing better record keeping on projects? Or are we just too soon in the process to be seeing how that is panning out?
I mean, I have to say, I have over the course of my career, I have seen much better record keeping on projects, and that's largely because of the electronic filing systems. There's a lot more awareness amongst parties to be not destroy records over every 2 years, for example. Everyone knows that they need to keep records for a while. I think the other thing for me that's made a massive difference is that I have seen on for international contractor clients have over the past, I would say 10 years, but particularly in the more recent 5 years, is my experience, have been recruiting ex-arbitration lawyers into their legal departments, and they provide an extremely important internal service that as soon as they get wind that there's any kind of problem, way before you would instruct external counsel, they're saying, right, let's make, where are your records? What's our policy? We're not allowed to destroy anything. What are we doing? Where are the records? And really making sure that everything is structured internally much better.
So exactly what Emma said is right. So in my experience, one of the Middle Eastern contractors, big sized contractors, EPC, has engaged an ex-arbitration lawyer from one of the renowned law firms. And that ex-arbitration lawyer has engaged a team where the team is preparing a complete manual how to avoid arbitrations. So they are preparing a full kind of a manual and procedures, standard operating procedure, which is going to be then circulated within the project teams and within the documentation teams and everybody. And trainings are going to be given that what you need to do in order to avoid arbitration, and in case you get into arbitration, how and what has to be done. And there is a dedicated team which has been engaged by that contractor just for this purpose.
I also find that it's partly a cultural thing as well. So it varies a lot depending on where your client is based and which jurisdiction you're working in. Because I mean, my time I've worked in, of course, UK cases and the Middle East, South Africa, Southeast Asia, and I can tell you, the more east you go, basically, there is a tendency that the record keeping quality just goes down, just by virtue of the fact.
Apart from the Japanese.
Apart from the Japanese, exactly.
It's just absolutely wonderful.
I know, it's just the best record keeping I've seen, probably bar none. Yeah, some Korean clients as well, they're also quite good with it.
Okay.
But yes, but generally, for instance, without generalizing too much, sometimes you deal with clients who are, let's say, based in China, and they just tend to correspond more with not so much WhatsApp or WeChat than with emails and letters. I suppose during COVID, where there was a lockdown, not everyone was on site, you get a sort of increased amount of sort of electronic sort of communication, which helped a little bit, but it's still not to the sort of level that you would expect in some other jurisdictions. So I think there's still a bit of work to do to sort of get that sort of record keeping culture across to sort of other jurisdictions as well. So then, when they come to this jurisdiction, for example, for an arbitration, there wouldn't be such a cultural shock where they're actually expected to produce documents rather than just, say something.
Well, certainly for the WhatsApp. I mean, Japanese clients are brilliant on records, but then when I told them recently, I also need to see all your WhatsApp messages, they kind of blanched. She goes, "What? You're allowed to do that?" And I said, "It's not me. They're going to be asked for." So, so this was a bit of a shock. So, which also leaves me a little bit nervous to find out what I'm going to get when we actually review all of these stuff. I'll update you next year.
I think we are past our time. One last question we can take if there is any. Yes.
So my question is based on contractor perspective. So if I'm a contractor and I'm purchasing an item, very major item from a country which is just got into a conflict with neighboring country and prices is going up. So I would, in a normal scenario, would go to my employer and say, this is the issues and my prices is going up. What should I do? So always a contractor is in a catch-22 situation, whether he go for alternate sourcing or he would wait for prices to go down. So as a legal expert, what you would say to a contractor that because my profit margins are very slim, should I wait for the prices to go down or I just go further?
Well, I mean, in that scenario, you're trying to work out whether it's going to cost you more to wait or to not wait. And if you're lucky, for the purposes of this scenario where you're trying to calculate your potential loss, you might have liquidated damages provisions that allow you to be reasonably certain about what your liabilities are to the employer. But it's not just your liability to the employer, you've got your own time-related costs, you've got your subcontractors' time-related costs. And so, and also in this scenario that you've outlined, you've got an uncertainty as to how long it's going to be for this price to come down, if at all. So you're staring down the barrel of a certain payment for delay versus a possible upside if something gets better on the pricing. It's unlikely, I think, that that is going to be a good thing to do, because you don't have the certainty, and the only certainty you've got is going to cost you money, and you don't know how long it's going to take for the price to recover, and you don't know how well the price is going to recover. So I think on a sizable project, time really is money. And so I think it's unlikely, if you sit down and do the calculations, that you'll find that it's cheaper, plus what do you put into that calculation, and you almost certainly miss loads of claims that are going to come at you if you delay significantly. So I would suggest it's unlikely to be cheaper to wait.
So in such instances, don't you think that the employer in the beginning itself should at least make in the contract some provision that if such kind of things, you see the world, the geopolitical situations, that something should be built in the contract itself so as to take care of such kind of risks?
Well, one of the things that we talked about when we were preparing for this session is the first thing almost every employer that does is strike a line through the price escalation formula, because employers want price certainty if they're contracting on a fixed price basis. And I think that's going to be increasingly difficult to justify. And I think contractors collectively, obviously not collaborating in a breach of market forces way, but if contractors are more insistent that this is just not tolerable for the market, that employers get their red pen out of the price escalation clause time and again, employers might not expect that that's what they're going to get. But it is difficult, and as I say, you do have to think a bit from the employer's perspective. The whole benefit of a fixed price contract from the employer's perspective is the fixed price.
I think with this, we come to an end. And
Final line.
sorry?
So you wouldn't have any other questions? That's why.
Yeah. So we don't have any further questions, and we can move ahead and have some snacks or something. Okay, thank you.